So please help me welcome, they are already on stage, our judge, Judge Fayeeza Kathree-Setiloane. And for Kalagadi, we have Advocate Gautschi, SC, as well as Ndumiso Luthuli. And then for IDC, AfDB, we have Vlad Movshovich, as well as Ahmed, Rajan, Qaasim, Ganey, Margeaux, Wassenaar, and Dr. Faadhil Adams. Please give them a big round of applause.
Good afternoon, ladies and gentlemen. It is not usual for judges to greet the parties, or for that matter, the audience sitting in the gallery. But today's session is slightly different. The session today will focus on the session today will be structured as a bench-led judicial arbitral dialogue, anchored by a focused advocacy component based on the recent decision of the Supreme Court of Appeal in the matter of the Industrial Development Corporation and the African Development Bank versus Kalagadi Manganese Pty Limited and two others. The session is designed to prioritize practical engagement, principal argument, and judicial insight rather than being a formal moot hearing. Now, central to this exercise today are two questions. Should arbitration agreements be strictly enforced, or should courts play a more expansive role in the adjudication of arbitral disputes? These questions were at the heart of the issues for determination in the Kalagadi decision that came before the Supreme Court of Appeal. There, the Supreme Court of Appeal reaffirmed the binding nature of arbitration clauses in commercial contracts. Now, the background to that dispute, which is relevant for today's session, is briefly this. In 2017, Kalagadi Manganese entered into a series of agreements with the IDC and the African Development Bank. These agreements included a loan agreement in terms of which the IDC and the African Development Bank granted loan facilities to Kalagadi for its operation as a manganese miner in the Northern Cape. Now, the relationship between the parties is obviously governed by these various agreements, the principal agreement being the Common Terms Agreement, which was concluded on 4 September 2017. Now, the Common Terms Agreement effectively provided that any disputes arising out of or in connection with that agreement had to be resolved through arbitration in London in terms of the International Chamber of Commerce rules. Now, Clause 5 of the Common Terms Agreement regulates the Kalagadi repayment obligations. Kalagadi defaulted on these obligations. The IDC and the African Development Bank, acting in terms of their powers under Clause 24.30 of the Common Terms Agreement, issued separate notices of default to Kalagadi, accelerating the entirety of the debt. Kalagadi was, in other words, obliged to pay the whole debt immediately. On 29 April 2020, the IDC instituted a business rescue application in the Gauteng division of the High Court. At the time, Kalagadi was indebted to the IDC in the amount of more than 3 billion rands. Currently, Kalagadi is indebted to the IDC and the African Development Bank in excess of 6 billion. Sorry, it's not 3 million rand, but 6 billion. So it's 3 billion and 6 billion. The application for business rescue was struck from the roll on 29 May 2020 for want of urgency. Now, the IDC is not only a creditor of Kalagadi, but it's also a minor shareholder in Kalagadi with a 20% shareholding. The major shareholders of Kalagadi are Kalahari Resources and Kalagadi Alloys. They are not parties to the Common Terms Agreement, but are parties to two separate agreements, namely the Guarantee Pledge and Cession Agreements, which were concluded in September 2017 with the IDC and the African Development Bank respectively. Now, subsequent to the IDC instituting the business rescue application, Kalagadi and its shareholders brought an application in the High Court to inter alia compel the IDC and the African Development Bank to restructure the debt. In addition to an order directing the IDC and the African Development Bank to restructure the loans to Kalagadi, the Kalagadi parties also sought an order directing them to consent to the termination of a mining contract concluded with Murray and Roberts, which Kalagadi blamed for the business rescue application. They also sought to interdict the IDC and the African Development Bank from exercising their security rights in terms of Clause 1.1.248 of the Common Terms Agreement, consequent upon their default. Now, Kalahari Resources and Kalagadi Alloys, the shareholders of Kalagadi, were party to this application, which I'll call the Kalagadi application. Now, in opposition to this application, the IDC and the African Development Bank raised a number of preliminary objections. The ones that are relevant for purposes of this hearing are, and I shall read this out to you as it appears on the papers of the applicants. Okay, the first objection reads as follows. The court is required to stay the exercise of its jurisdiction to determine the merits of the Kalagadi application. Clause 40.2.1 of the Common Terms Agreement provides that any disputes arising out of or in connection with the Kalagadi application, any disputes arising out of or in connection with the agreement must be resolved through arbitration in London, United Kingdom, under the International Chamber of Commerce rules. The substantive law of the Common Terms Agreement is also English law. Kalagadi's attempt to bypass this arbitration clause and bring the matter before a domestic court contravenes the agreed-upon dispute resolution process. The second preliminary objection raised is that, for purposes of this hearing, is that AfDB, the African Development Bank, a respondent in the Kalagadi application, and a necessary party in that application, is immune from the court's jurisdiction under Article 52 sub 1 of the African Development Bank Parent Agreement, which was given effect to and recognized inter alia by Article 4 of the African Development Bank Host Agreement, recognized and enforced through South African law, specifically the Diplomatic Privileges and Immunities Act 37 of 2001. Pursuant to the Host Agreement concluded with the Minister of International Relations and Cooperation of the Government of the Republic of South Africa. Since the African Development Bank is a necessary party to the application and cannot be subject to the jurisdiction of the South African courts, the court is divested of jurisdiction and the entire application is rendered defective as relief cannot be granted against the African Development Bank and it cannot otherwise be joined to the proceedings. The High Court found, sorry, let me just, 1 second. Okay, sorry, on 30th October 2020, Kalagadi launched a further application in which it inter alia sought a joint hearing of the business rescue and Kalagadi applications. The High Court heard the application on 30 January 2021. On 22 July 2021, it ordered a joint hearing of the two applications on the basis that the substantive adjudication of the one application involves a consideration of the factors raised in the other, and it may be more convenient not to require their regulation simply for the sake of form. The High Court did not order a consolidation of the two applications. However, on 3 December 2021, the High Court heard only the preliminary objections raised in the Kalagadi application and the business rescue applications. It did not deal with the merits of these applications. On 6 September 2023, it dismissed the preliminary objections in the Kalagadi application in paragraph 3 of its order. The applicants then applied to the High Court for leave to appeal, which the High Court refused. They subsequently applied to the Supreme Court of Appeal for leave to appeal, and that application was opposed by the respondents. Well, in that case, the Kalagadi parties. The SCA referred the application to open court for a hearing in terms of 17.2, for an oral hearing in terms of 17.2D of the Superior Courts Act. It is that application that is now before us. The parties will deal with, the court had ordered the parties to deal with both the question of the application for leave to appeal, as well as the merits of the preliminary objections that were raised by the IDC and the African Development Bank. I now hand over to Counsel.
Yes, thank you very much, Justice Kathree-Setiloane. As was mentioned at the outset, we represent the IDC and AfDB. I'm here with Mr. Rajan, Dr. Adams, and Ms. Wassenaar. The matter has two components, two main components. One is the immunity question, and then the arbitration question. If I can orientate, maybe if I may orientate everyone in relation to the record that's in the pack. The first page is just an outline of the matter. Then the second page is a list of what the record contains. On page 3, if I may take you to page 3, that has provisions of the Constitution, relevant provisions of the Constitution, section 34, 36, and 231. Those sections are relied upon by Kalagadi respondents. We say that they are largely inapplicable for the purposes of this matter. 4 is the Diplomatic Immunities and Privileges Act. That's the legislation that gives effect to the immunities we say in this matter, and I'll take the court to that. Then 5 is an extract from the International Arbitration Act, to which the model law is a schedule. And obviously we say that the International Arbitration Act is applicable and must be enforced in its terms. 6 is the host country agreement between South Africa and African Development Bank. That is the agreement that gives effect to the parent agreement of the AfDB and all the immunities. 7 are the extracts from the parent agreement, which I've just mentioned, and 8 contains the key dispute resolution clause in the common terms agreement. So that's just to orientate everyone in relation to what's in the pack. I'll be referring to these documents throughout my address. So the first question is one of what really happened here. So as was outlined by the court, it's finance agreements were concluded by the parties in 2014 and 2017. Those finance agreements contained repayment, a variety of repayment obligations, as one would expect. The parties to those agreements for present purposes were the AfDB and the IDC as lenders. There was also APSA, who was a lender, but APSA has fallen out latterly. So AfDB and IDC were lenders, and they lent substantial amounts to Kalagadi. Kalagadi is the borrower. Because this is a finance package, Kalagadi, whilst Kalagadi was the main borrower and was the party that was liable to repay the debt, there were security instruments that were also signed to support the recovery of debt should Kalagadi not be able to pay. And therefore, that's where the shareholders came in. They pledged their shares and they pledged their interest in Kalagadi to the lenders as security for the transaction, which is quite normal. But the common terms agreement itself was concluded for present purposes only between Kalagadi as the borrower and the two lenders. The security instruments, which are separate agreements, were concluded between the Kalagadi shareholders and a special purpose vehicle set up for the purposes of realizing security should it be necessary. So that's the framework that was agreed. And under the common terms agreement, which is binding as between Kalagadi as borrower and the lenders, there is the dispute resolution mechanism. And I'd like to take the court to that on page 5 of the bundle. That sets out in 40.2 the jurisdiction question. And that is that's a pivotal aspect of the arbitration, of the argument on arbitration. It says, subject to clause 40.2.10, any dispute arising out of or in connection with this agreement, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration under ICC rules. And then, as the court has pointed out, what we also contend is that it's clear from the clause that this would be under English law, it will be in London as the legal seat of arbitration, and it will be pursuant to strict timelines set out in this clause.
How should the court interpret this?
Yeah. So this is what this is the nub of our argument. Yeah. We say that the disputes that have been raised in the Kalagadi application, which have been raised before the High Court, are actually disputes that arise out of this agreement, arise out of or are in connection with this agreement. And therefore, each of the disputes, and I'll just maybe give a summary of the disputes. The disputes are effectively that Kalagadi disputes the obligation to repay the loan facilities. That's the first main dispute. The second dispute is a dispute relating to whether the financial model which underlay the whole agreement should be changed. And then there are also other assumptions that Kalagadi contends under the agreement are erroneous.
Yes, but what in this particular clause makes the referral to arbitration peremptory?
Yes, thank you. That's clear from 40.2.1 in the first place, because it says any dispute arising out of shall be referred. So the language that's used is peremptory in its terms, and there are cases without number which say that firstly arbitration clauses are generally interpreted as being peremptory, unless the wording is otherwise. But where the parties have stipulated it in peremptory terms, that will be given effect. And Lufunum Papuli case that was heard by the Constitutional Court and decided by the Constitutional Court has effectively said that constitutional rights of access to court and the like are not relevant in the context of arbitration, because because what the parties do through their arbitration agreement is agree not to exercise their constitutional rights. They're not waiving the rights, but they're simply deciding to...
Can I just take a step backwards? So basically there's no scope for the exercise of discretion here.
So I'll come to that if I may be allowed to develop that part of the argument, because that's a critical part of the argument. But I think I'd like to develop it when we get to Article 8 in the model law, because that makes it clear in what circumstances the court can intervene and can disregard the arbitration agreement. And we say that those circumstances are not present in the current case.
Now, the actual arbitration agreement, what is the nature of this agreement? Is it an international agreement, or is it a domestic arbitration?
Yes, so that's so I'll move on to the arbitration, the applicability of the International Arbitration Act.
Yes.
As was clear from the High Court judgment dealt with it as a domestic arbitration matter under the Arbitration Act of 1965. We say that that is an error, and the International Arbitration Act is applicable, and we say so for two reasons. The first is that African Development Bank is incorporated and has its principal place of business in the Ivory Coast, which means it is not one of the parties to that agreement is therefore not a South African party. And secondly, the seat of the arbitration is London, which means it's outside of the place of business of the parties and outside of the realm of South Africa. That, in terms of the International Arbitration Act, definitionally makes it an international arbitration agreement, and therefore the International Arbitration Act is applicable.
Okay. Now, what is the test under the International Arbitration Agreement?
Yes, so if I may take...
to whether an arbitral dispute should go to arbitration or to the court of the applicable country.
Yes, Justice, and if I may take you to page 4 of the bundle, that sets out Article 8, the provisions of Article 8 of the International Arbitration Act.
Sorry, so it's page 4?
4.
Pardon?
The paginated page 4.
Are we all on the same page here?
I'm hoping so.
Yes. Article 8.
So Article 8, this is, the International Arbitration Act has two components. One is the main body of the Act, and then it cross-refers to Schedule 1. It incorporates the model law into South African law, and this is an extract from Schedule 1. So Article 8 of Schedule 1 has the following provisions, and this is a uniform provision that applies in all model law jurisdictions. This is the way one adopts the model law, and that's quite important for the purposes of our argument relating to what context the court should take into account in deciding how to interpret Article 8. Article 8.1 says a court before which an action is brought in a matter which is the subject of an arbitration agreement. An arbitration agreement here is defined as an international arbitration agreement, shall, if a party so requests, not later than when submitting his or her first statement on the substance of the dispute, stay those proceedings and refer the parties to arbitration, unless it finds that the agreement, and this is the operative part, is null and void, inoperative, or incapable of being performed. Okay. So that is the test we submit that the court needs to apply, and the test is a strict one. And if we look at the case law, at the UNCITRAL case law digest, and if we look at UNCITRAL travaux préparatoires, which are relevant to interpretation of this, it's clear from those instruments that it's meant to be a very narrow set of exceptions.
Yes. How does the test under the International Arbitration Act differ from the test in the domestic arbitration?
Yes, so under the Arbitration Act of 1965, there's Section 3 and Section 6. Section 3 of the Arbitration Act of 1965 says that where the court may, in the exercise of its discretion, which has effectively been interpreted to mean where justice demands, may order that the disputes which were subject to an arbitration agreement actually proceed before court. Now that
Is that correct, where justice demands? It's not on good cause or something? Good
yes,
cause show?
no, well, it's been interpreted as meaning where justice demands, but the courts have also said that should be exercised only in the clearest of cases where a compelling case has been made out. And that's clear from Constitutional Court and SCA authority on the point. The case that I would cite for that proposition is the De Lange case, which went through to the SCA and then went up to the Constitutional Court, and I think Justice Moseneke wrote the judgment there. And he said, well, it needs to be narrowly interpreted, and if the parties had willingly agreed to submit it to arbitration, the court should intervene in rare cases. But at the same time, we must acknowledge the fact that in domestic contexts, the courts have referred matters to arbitration where, for instance, there was a multiplicity of parties, or where there were overlaps in evidence, and therefore it would be completely inconvenient to refer it to arbitration. Whereas,
can I just stop you at this point? It's not clear from the High Court judgment that, well, firstly, the High Court did not apply the International Arbitration Act to the issues before it. It applied an interest of justice test, which it then said was in the interest of justice to basically refer this to arbitrate, to refer both the business, to refer the arbitral dispute to it to deal with in the High Court, and basically for the business rescue and the arbitral dispute arising out of the Common Terms Agreement to be dealt with together. But there wasn't an actual consolidation of the two applications. Am I correct?
yes, correct. There was no formal consolidation. What the court found is that it was convenient to hear both together because they had overlapping facts and circumstances. Yes. So the
and
court.
Is that correct?
Well, there are overlapping facts, certainly.
Yes.
But the business rescue application does stand on its own, in its own terms as compared to the Kalagadi application. The business rescue application is an application that was brought by the IDC for the purposes of placing Kalagadi into business rescue. It could only be brought in court. And that concerned whether that application is good or bad, concerns whether the test for financial distress was proven and whether IDC had standing as a creditor and the like. So there are statutory requirements. It can only be brought before court, so that's not an arbitrable dispute.
Yes, and the relief, as I understand it, the relief sought in a business rescue application is quite different to that is sought in the Kalagadi application.
Yes, absolutely.
Okay.
What the Kalagadi application seeks to do is to interdict any enforcement of the Common Terms Agreement and to force the lenders to restructure the debt, essentially, and to revise a financial model and the assumptions. All of those are central elements of the Common Terms Agreement. So the dispute that was brought by the Kalagadi application is squarely one arising or in connection with the agreement, and we say that under the requirements of Article 8, which we've just adverted to, it's clear that agreement is applicable to these disputes. The question then arises is it null and void, inoperative, or incapable of being performed for any reason? And what the case law has illustrated from all over the world, and the model law is an international instrument, and Kalagadi relies now on a few other cases to support its case here, and we'll hear from them on the Supreme Court of Canada case. But we say none of those authorities assist them, because those authorities in fact assist the IDC and AfDB's case, because they make it clear that those requirements of null and void essentially means, is the agreement tainted by something that makes it from the outset completely ineffective? there is no such case that's made out. So that's the first potential exception. Second, is it inoperative? Well, what the case law makes clear, in fact, it's a case that's been raised, the Supreme Court of Canada case, and I'll refer to it here, and if there's anything...
I'd prefer it if you raise that in reply.
Reply. There's no difficulty with that. I'm simply saying that...
I'm sorry, I haven't had sight of that judgment.
So I'm just saying that judgment makes clear that inoperative means that where there are some supervening circumstances that occur that make it impossible to implement or completely inappropriate to implement. And in that case, there was a supervening liquidation where the liquidator had effectively found that or decided not to be bound by the arbitration agreements, and the court found that everything should go to court. And I just want to, I'm not going to deal with it in detail, but I do want to say that that case says that inconvenience, multiple parties, intertwining of issues with non-arbitrable disputes, possible increased costs, and potential delay are not grounds to make it inoperative as contemplated in Article 8. And therefore, we say that case is dead set against Kalagadi.
Are you saying none of those considerations apply?
Applies. Well, we say no. We say they apply, but
yes.
this they might apply. But this case makes clear that that's not what's contemplated by the words inoperative or incapable of being performed, because those are very narrow categories where effectively you have a supervening set of circumstances where the agreement can't be implemented. Now, there is no suggestion that the agreement can't be implemented. All they're saying is that it's inconvenient or it's unjust to make them subject to this legal process and another legal process.
Can I just go back to the relief sought?
Yes.
There is interdictory relief sought against the IDC and the African Development Bank from basically calling up the guarantees. Am I right?
Yes.
Now, if the court were to agree that this matter should be referred to arbitration, what then happens to the rights of those shareholders, Kalagadi Alloy and Kalahari Resources, insofar as the interdictory relief goes in this matter?
Well, insofar as the shareholders have any interest that they need to protect in the interim or finally, under the security agreements, there are dispute resolution provisions, and those dispute resolution provisions would govern that exercise. Those security agreements, I should just point out, aren't even directly between the lenders and the shareholders. They are between special purpose vehicles that house the security, and therefore there might be litigation or there might be arbitration or other dispute resolution
But will they
processes.
impact on the enforcement or the enforceability of the common terms agreement?
No, so that's what I wanted to distinguish,
Yes.
is that the common terms agreement was entered into between Kalagadi, the borrower, and the lenders. And they've agreed to these dispute resolution mechanisms in Article 40 or Clause 40 of that agreement for the purposes of resolving disputes inter se. Just because there might be disputes relating to security that involve the SPV and the shareholders doesn't mean that this clause is inoperative in any way. Those are different disputes, and we know that security, the persons who have given security have the right to defend themselves in accordance with the law, and those provisions of those agreements would govern the dispute resolution of those
So you're
matters.
saying that even if this matter has to go to arbitration, their rights are not impacted at all?
Yes.
They still have an opportunity to interdict in the event that the IDC and African Bank decide to call up those guarantees. They would still have the right and the opportunity to basically interdict them from doing so.
Yes, and they're not bound by the arbitration agreement in the common terms agreement. They are bound by their own agreements, and this matter is about referral of the main dispute. What we mustn't lose sight of.
It concerns me.
Yes.
it concerns me what's going to happen to their rights
Yes,
at the end
of
of the day. I mean, they do have rights in this. They are major shareholders.
Yes.
And so what, from a practical point of view, in the event that the court decides that this matter, should be stayed and be dealt with in London,
Yes.
practically, how does the court achieve this?
Well,
How does it excise the concern that it has in respect to these shareholders?
Yes, well, obviously, only parties who are subject to the arbitration agreement can be forced to arbitrate. And here it's Kalagadi and the lenders in relation to that
Kalahari,
dispute.
Alloy and Kalahari Resources, they are not party to the common terms. Is that clear?
Yes.
Is that right?
Absolutely.
Okay. So even if the dispute goes to arbitration, it will not impact any rights insofar as security is concerned.
Absolutely. Absolutely. And they might have
because they certainly are part of the Kalagadi application.
Yes.
They may not be parties to the common terms agreement, but they are parties to the Kalahari application.
And there's a wide range of disputes that's raised in the Kalagadi application.
Yes.
Most of them concern the common terms agreement, but insofar as there's something that concerns the security agreements, then that needs to be dealt with under its own dispute resolution mechanism, which is not the subject matter of the referral or the stay that we seek.
And what is the core concern in the Kalahari application? That there's been a breach by the IDC and the African Development Bank of the terms of the common terms agreement, am I right?
Correct. And that the financial model needs to be revised, and the assumptions need to be revised, and that the debt is not enforceable effectively, the debt under the common terms agreement. And an argument has been raised, or one of the arguments, and I do want to, we've dealt with most of the arguments that are raised from the other side, but one of the arguments that's raised is they say, well, IDC has an obligation under its own statutes to act as an organ of properly as an organ of state, whether that's reasonably or otherwise. So when it exercises its contractual rights, it must do so with a view to fulfilling its mandate under statute. Now, we say that's bad on the merits, but for purposes of the current matter, we take the merits as they stand. We say that that's also a dispute that's arising or in connection with the agreement, because it's settled law that arbitration agreements are to be construed holistically and practically in a business-like sense, which means that business people, when they conclude, especially major finance transactions, they don't envisage a situation where one part of the dispute is going to be decided in this forum and another part in that forum. They agree that all disputes in any way in connection with the transaction have to be referred to arbitration. That's what happened here, and therefore IDC and others can raise whatever.
But then you have. I mean, I understand that, but you have the Kalahari application, but prior to that you have the business rescue application.
Yes.
Now, was it competent for the IDC to bring that business rescue application? Did it require some authorization in terms of the agreement to bring that, or was it allowed to bring that despite what the common terms agreement?
Yes, so that's another aspect.
So far as the resolution of disputes are concerned.
So one of the aspects that are raised is what I've mentioned just now. Another aspect is this, that they're effectively saying by bringing the business rescue application, then it's fair game for Kalagadi to come to court with the substance of the Kalagadi application, because it contends that it is, although it's a separate application under a separate case number, it's actually a response to the business rescue application. We say that it's not correct that it's a response, but even if part of its defense is that the debt is not due because of all of the issues under the common terms agreement, that's still a dispute under the common terms agreement. And once that arises...
So you're saying there may be some overlaps?
There may be overlaps, absolutely.
Yes.
And it might have an impact on the progress of the business rescue application. But non-constat that you then the court can simply decide the common terms agreement disputes as though it has jurisdiction and has power to do so. The reality is that if a dispute relating to common terms agreement and application of it arises, it must be referred to arbitration. It might have an effect then on other proceedings, like the business rescue proceedings, because Kalagadi uses that as a defense in that context. But it's still, the disputes under the common terms agreement or arising in relation to that have to be referred to arbitration. And in respect of whether IDC, just to answer the court's query, in relation to whether IDC could launch business rescue proceedings or needed some authorization. It didn't need that authorization, and that is not suggested.
There is a provision in the common terms agreement that allows the financing parties to make an election.
Correct.
To go for the dispute to be dealt with by way of litigation. Was that election made here?
No.
So far as the business rescue application is concerned, and was the election required in order to bring the business rescue?
Yes, we say that election, the common terms agreement, when it refers to the right of the finance parties, the court is quite correct that effectively the common terms agreement says there's peremptory arbitration, but if the finance parties decide that they want to go to court instead, they can do so. We say that election has not been made because the business rescue is not a dispute. Business rescue application is not a dispute in terms of the common terms agreement. It doesn't seek to enforce the common terms agreement in any way. It makes use of a novel provision in the New Companies Act to place Kalagadi in business rescue. It doesn't through that prove or disprove the debt, and it doesn't enforce the debt under the common terms agreement.
Very well. So the relief sought there is quite different, and the outcome there is going to be quite different to what the outcome or the relief that is sought in the Kalagadi application. But tell me, I need to understand this. What has happened to that business rescue application? What is the status currently? It was never dealt with by the High Court, despite the fact that there was the High Court ordered that they be dealt with jointly without formally consolidating the two applications.
Yes, so it was first struck off the roll in May 2020, urgent roll. Yeah. Then the matter was referred, matter was then referred to the Commercial Court. Yeah. Commercial Court, as the court correctly points out, decided to hear both together. Then the in limine points, which are the subject matter of this application for leave to appeal, were separated out for separate adjudication. And those are the points regarding arbitration, immunity, and other dispute resolution mechanisms that we say have to be enforced. Given that, and given the previous directive that the two applications should be heard together, everything has been pended until the outcome of this application for leave to appeal and any further processes on the in limine points are exhausted. And so from a practical perspective, nothing has happened. What impact that might have on the business rescue application will depend on what the court rules on this application for leave to appeal.
Now given that the IDC, and you touched on this, is an organ of state, it's a public body. There's one school of thought says that public bodies, in particular organs of state, shouldn't engage, in the formulation or agreeing to arbitration agreements. Is there any merit in that?
So the International Arbitration Act makes it very clear that public bodies are, first of all, allowed to arbitrate, and the arbitration agreements they conclude are binding, except insofar as the Protection of Investment Act 2015 is concerned. So that's the only carve-out. The only other issue that might be of relevance is that when you involve public bodies, sometimes international arbitrations are not treated as confidential unless the parties agree otherwise. So those are the only two minor modifications to the general principle that public bodies are bound. We say public bodies in this case are absolutely bound, and also Kalagadi has not raised the issue that the agreement should be struck out or is contrary to public policy or anything of that nature. It accepts that it has concluded this agreement. It accepts that it is bound by it. It simply says that under the now International Arbitration Act, but originally Arbitration Act of 1965, this is an instance where the court can disregard that agreement. That's essentially what that part of the matter is about. And we say that all of the grounds...
The fact that this organization, the IDC, has certain statutory obligations, as well as constitutional obligations,
yes.
to to the parties to whom it lent, it financed, basically. Does that make any difference insofar as whether this should, the court should have a more expansive role in arbitral disputes?
Yes, so we say that the rights and obligations of the parties are squarely within the four corners of the Common Terms Agreement, and that those obligations are not applicable. But insofar as the Kalagadi wants to raise any of those issues, it can do so within the arbitration forum, and it can raise what impact it makes on exercise of acceleration rights, for instance, or enforcement rights. It's welcome to raise that. I should just point out that it's been settled law, certainly since 2001, the Cape Metro case, where the court has said that once a contract is concluded, even if there was an antecedent exercise of public power, once a contract is concluded, the rights and obligations of the parties are governed by that contract. And we say now this is a paradigm case of that, because here we have a major finance transaction involving both South African and non-South African parties, where a lot of money has been expended to finance a business venture. And the parties have signed agreements spanning hundreds of pages to suggest that there are some unstated obligations. Obligations are not stated in those agreements which should be binding, we say is risible. But all of whatever arguments they want to make on the merits, they can do before the arbitral tribunal. Our submission is that they will have an ample or more than ample opportunity to do to deal with those issues in that context.
Can I just ask, in the business rescue application, did the African Development Bank, was the African Development Bank cited as an applicant in the business rescue application?
No, it wasn't. It was only the IDC that applied.
Yes.
And the suggestion by Kalagadi is that the AfDB has acquiesced. They don't have any evidence of it, and there's no evidence on the papers that there's been any acquiescence in the business rescue application. But that's one of the grounds on which they say the court should overlook the arbitration agreement, because AfDB and IDC have effectively joined the business rescue application implicitly or otherwise, and the court has jurisdiction over that, and it must decide everything. We say that that's incorrect for all the reasons I've already pointed out. But in addition to that, it's not, even if AfDB had acquiesced, we say that it is irrelevant, because the dispute, once a dispute is raised, and it has only been raised in this Kalagadi application by Kalagadi in relation to whether Common Terms Agreement is enforceable, and whether the model should be changed, and all of those matters that are under the Common Terms Agreement, it must be decided in terms of the provisions of the Common Terms Agreement, which includes Clause 40. And we say it's not an answer to say whatever AfDB or even IDC had done before, it doesn't constitute a waiver of Clause 40. They couldn't have brought the application for business rescue in any other way other than to the High Court. It's not a waiver of anything. You can't read into an exercise of a statutory right.
They didn't waive the right to refer the arbitral disputes.
Arbitral disputes to arbitration.
Yeah.
Just because you exercise a statutory right to apply for business rescue, which is not an arbitrable dispute in terms of Clause 40.
Can I? I'm watching the time, and
yes.
We're already 51 minutes into
yes.
the hearing.
And I do need to get to immunity.
I'd like you now to proceed to the question of
yes. I think we've dealt with whatever I need to deal with on arbitration. I'll deal in reply. Yeah. On immunity. So this is a second leg to our argument. So the relief, we say that arbitration as a result of the arbitration provision, International Arbitration Act provisions, this court is obliged to refer those disputes to arbitration, or to direct that they be referred to arbitration, even without there being the immunity point. We say the immunity point is an additional basis on which the court cannot, in fact, exercise its jurisdiction at all. And we say so for the following reasons. We say that African Development Bank, as is accepted by Kalagadi, is an international organization. It is based in Ivory Coast. It is an international development financier. Its business is making available financing for development projects on the African continent and beyond. It gave a very substantial sum to Kalagadi in 2014 and 2017 under those agreements, and it is protected in the context of South Africa by immunity from suit and enforcement in South African courts. And that's captured in, if I may take the court to the relevant provisions, it's captured in the host country agreement, which is at page 4 of the bundle. It's mentioned at page 4 of the bundle, at the bottom of page 4. The pagination is at the bottom of the pages, unusually for an appeal record.
So we have the host country agreement, which that is not attached.
So yes, we don't have the actual copy of it in the record. I'm saying that it's mentioned at the bottom of page 4.
Yes.
Yes, and then but the key provisions that we rely on are at page 5, paragraph 7 of the note. And that sets out the parent agreement of the African Development Bank. Now, just to take us back a little bit, 4th of August 1964, I think, 1963, the African Development Bank was set up. It was set up as an international finance organization, and many countries signed up to its charter. South Africa was not one of those countries. It acceded later on to the parent agreement. It acceded in 1995. Under that parent agreement, which hasn't changed to date, from 1963 to date, and which South Africa has acceded to in 1995.
Can I understand, before we get to that point,
Yes.
can you just briefly, I need to understand
Yes. Yes.
how the host country agreement relates to the parent.
Yes, so I wanted to, let me deal with that before I get to the parent agreement itself.
Yes.
So the host country agreement, which was concluded in 2009, and then was reconfirmed in 2017, there are 2 sets of publications of that agreement, essentially incorporates all of the immunity provisions from the parent agreement into South African law. And so it makes it a part of the host country agreement. Paragraph 50, Article 52 and 59, which is over the page, at page 5, of the parent agreement are made part of the host country agreement in its terms, in terms of the host country agreement. And the host country agreement in turn is made part of South African law by virtue of the Diplomatic Privileges and Immunities Act of 2001.
It's in terms of the parent agreement that the bank enjoys immunity. Am I right?
Yes, the host country agreement also speaks about immunity, but we rely mainly on the parent agreement as incorporated by the host country agreement. And that's why Article 52 then assumes importance, which is at page 5. It says the bank shall enjoy immunity from every form of legal process, except in cases arising out of the exercise of its borrowing powers, when it may be sued only in a court of competent jurisdiction in the territory of a member in which the bank has its principal office, etc. All of that is not critical. The most important part is the first 2 lines of that provision, which say the bank enjoys immunity from every form of legal process, and the only exception is the borrowing powers. Now, we've illustrated to the court that what's being...
every form of legal process, does that not also include arbitration?
Yes, and absolutely. That's absolutely correct. It does include arbitration. It includes every form of legal process. And I'll come to how what impact that has on this case.
Okay.
But in terms of I just want to position what our argument is in relation to whether the substance of the dispute is one that concerns borrowing powers. We say it doesn't, because in this case, AfDB was lending money, and it's part of its lending functions that are the subject matter of this dispute, and therefore the exception doesn't apply. So in terms of subject matter or substantive subject matter jurisdiction, we fall squarely within this context. What's the consequence of that? The consequence, we say, and just to lay the legal framework, the consequence of that is that under the parent agreement, it enjoys that immunity. That's an immunity in international law. That, we say, has been incorporated into South African law through the host country agreement and the Diplomatic Privileges and Immunities Act of 2001.
Okay.
Because,
yes. But how does Section 231 of the Constitution relate to these two agreements?
Yes. Section 231 is not directly relevant for purposes of this case, because what has happened, insofar as it's relevant, I'll address it just now. But in terms of our first argument, our main argument, is that Parliament has passed legislation in 2001 which allows the Minister of International Relations and Cooperation to publish agreements that he or she has concluded with international organizations. Once those agreements are published, they become part of local law. They are domesticated under Section 5.3 and 7.2 of the Immunities Act. And once that is so, then we are not looking at the Constitution at all, because it's not a question of the Constitution. It's enforcing the Immunities Act. If there had been a constitutional challenge...
Are you saying that the immunities conferred by the legislature in terms of the Immunities Act, and therefore 231 has no application? There need not be any further ratification,
incorporation or ratification. Absolutely. So just to take the court, because it's quite an important point, to take court through the reasoning. The reasoning is that we have a statute which allows, so for instance, had there not been an international agreement, the legislature could very comfortably, in Section 5.3 of the Immunities Act, say the following organizations have immunity from all legal process. And they could have listed the African Development Bank. What it did here, as it does with a million other cases of delegation to executive, it delegated its powers to confer immunities on a member of the national executive. There's nothing wrong with that, and it's done all the time. Our bureaucracy would not be able to function without proper delegation. It has delegated that power. That power has now, the delegated power, has been exercised to the minister.
To the minister, yes.
The minister has exercised those powers, and there's no dispute that she's exercised those powers. She's signed the 2009 agreement, and that was republished in the Government Gazette, and it was republished in 2017. That then means the legislature has exercised its power to confer the immunities on AfDB.
But prior to the conferral of the immunities by the minister, that delegate power, were there already these agreements that were entered into between...
The parent agreement was already incorporated, and I'll come to that point, but I don't want I want to emphasize that we rely in the first instance on the host country agreement and the Immunities Act read together, which confer the immunities. And there's no constitutional challenge. Had it been the case that Kalagadi wanted to say Section 231 of the Constitution precludes you from Immunities Act from providing for the minister to confer immunities, well, then we would have been in a different universe. We are not in that universe. We're in a universe where the act is unchallenged. So there was no challenge
to the minister's powers under that act?
Correct.
And was there any constitutional challenge to the act?
No challenge is before the court. And therefore, the legislation must be applied in its terms, obviously using the usual triad of purpose, context, and text. But the we are still dealing with the legislation. We're not dealing with some broader constitutional challenge question. It is true that the parent agreement was incorporated, was ratified by Parliament in 1995. Before the host country agreement was concluded and before the Immunities Act power was exercised. We are not, we say that's an independent basis on which we also come home in this matter, but the court need not reach that question because there's a clear statute which gives effect to the immunity. So we don't even need to deal with Section 231 of the Constitution and ratification or anything of that nature. And we say the provisions are very clear, and there's a case, the court will know that there's a U.S. Supreme Court judgment which has now been... Can I
just go back to that earlier question that I raised, the question about...
the arbitration. I'll come to that, whether that's legal process.
Well, the width of the term legal process. I mean, that would cover arbitrations as well. So it means a party such as Kalagadi will have no recourse against the African Development Bank.
Yes.
Even by way of the arbitration mechanism. Now, that can't be right. That has to be, I mean, I have a difficulty with that.
Yes. I take on board the difficulty. I'll deal with that immediately after I make this further point. What I wanted to say is in relation to the case that's been raised, it's a case of JAM versus the International Finance Corporation. It's not in the bundle, it's in the authorities. And that case, that's not the Supreme Court of Canada case, it's the US Supreme Court case. Okay, yes. And it's relied on in supplementary heads, which were filed a week before the hearing. But that case doesn't assist the Kalagadi. It effectively, that's a case that dealt with parochial U.S. legislation, which has a specific commercial transactions exception. South Africa does not have a commercial transactions exception. And the JAM case, the Chief Justice Roberts in that case, made it very clear that if your agreement, your international agreement of the international organization, actually is sufficiently broadly framed to cover all legal process, then it will be enforced in its terms. And the commercial transactions exception is not going to be applicable.
But is it appropriate from a constitutional point of view to have absolute immunity like Kalagadi has in this case? Well, on a reading
like AfDB, yes.
The African Development Bank.
Yes. So it's is
that the modern approach to? I mean, basically these are commercial players.
Yes.
Shouldn't then the rules of the marketplace then apply?
Yes, we have the Belgian Court of Appeal case, which interpreted that provision of the AfDB's parent agreement to mean it's immune from all processes. So there's international case law which upholds that notion. It's also a provision which has been passed in 1963.
It's basically immune from all processes.
So Justice Kathree-Setiloane, we submit that in this case, it would make no sense for it not to have immunity in relation to this kind of transaction. And our reasoning is threefold. Firstly, the terms of its immunity are very clear, that they cover all legal process. And when you have a commercial transactions exception...
So do they cover arbitration disputes as well?
Yes, but I'm going to deal with the arbitration disputes. I'm dealing with the commercial, because one of the points that's raised by Kalagadi is that commercial transactions are excluded. And they say, this is a commercial transaction, therefore it's excluded. It's the usual commercial transactions exception. I'm dealing with that point first. I'll come to the arbitration, I promise. Okay. I just think it's important before we move...
Because it's important that there be an alternate remedy.
Yes. Absolutely. No, the alternate remedy I'll come to. I'm saying in the commercial transactions exception, it's clear from the wording, and our first point is, it's clear from the wording of Article 52 that it covers all legal process and there's no commercial transactions exception. Whereas in US legislation and other statutes, there is an express commercial transactions exception. There is no such exception in the host country agreement or in the parent agreement or anywhere else. That's the first point. The second point is that the commercial transactions, it would make no sense to interpret Article 52, which is on page 5, in any way as not applying to the AfDB's lending function, because that's the only time that it's going to conclude agreements which are going to be the subject of this immunity. That's its business. So for its lending transaction not to be covered by this immunity would do violence to this immunity, would put a line through this immunity. And therefore we say it's simply not an available interpretation. The interpretation must include its lending functions, which puts us squarely, the common terms agreement, squarely within the context of this matter, and this and the being an arbitrable dispute. So we say for those two reasons, as well as the third reason being the case law that's relied on by the Kalagadi itself, we say supports our case, which I've already traversed. I won't retraverse it. I'll now move on to the arbitration point, which is obviously a very important point. So the point is this, that's made by Kalagadi, if I can just summarize it. They say, no, but yes, there's this arbitration clause, and yes, it might fall within arbitrable disputes, but 40.2.9, if I may take the court to that, on page 6, says, the parties hereby acknowledge and agree that nothing contained in this agreement or any other finance document shall be construed as a waiver, renunciation, or other modification of any privileges, immunities, and exemptions accorded to AfDB under AfDB Charter, international law, or other applicable treaties, etc. So they argue, they say, no, but that means that 40.2.1 is a dead letter. That effectively we can go to arbitration, but you haven't waived your immunity, so you'll just say you are immune from that suit. Now,
that's a real concern.
Yes, we say that that's not a proper interpretation of Clause 40. The interpretation must be holistic. That's our first argument. Our first argument is that there must be a holistic...
How do we interpret Clause 40.2?
Because 40.2.1 is a clear submission to jurisdiction of the arbitral tribunal. Clear.
Yes.
40.2.9 must be interpreted in light of that. What it's saying is that the parties acknowledge that there are these immunities, and that except insofar as there's an express waiver, clause doesn't constitute a waiver for all times, because there could be a whole host of other disputes and other issues that are the subject matter of the immunity. AfDB is very precious about its immunity, and therefore it wanted to preserve it.
Does it allow AfDB to waive its immunity?
Absolutely. Well, it has waived. We say it's waived it under 40.2.1 already. And as the court will see, the papers make it clear that it's the finance parties that contend that the matter should be referred to arbitration and that it should be subject to arbitration. Therefore, that is a further reconfirmation insofar as you needed any waiver of immunity, an additional waiver. That's our second point, that the papers in this matter make it clear.
Is there a resolution from the board?
Yes.
Of the AfDB, basically agreeing to the waiver of its immunity?
Yes.
For purposes of the arbitral dispute?
Yes. Justice Kathree-Setiloane, the parties, there's been no challenge to the authority of the AfDB deponent to act on behalf of AfDB for all purposes, and for us to act on behalf of AfDB for all purposes. And under Rule 7, and in terms of the prior case law, it's clear that we can represent AfDB for these purposes. The immunity has been, we say it's been waived already in terms of the Clause 40. Insofar as that's not the case, we have waived it in the affidavits, and we give a tender in any event to court, in open court, that is our position. And we are obviously fully authorized.
As I understood the contentions raised in the affidavits, it was, this point was raised by the by Kalagadi parties, but the IDF and AfDB didn't deal with it. So are you waiving it on behalf of the board now?
We say we did deal with it, yes. Justice, we say we did deal with it.
Okay.
We say we have addressed it, and we said that the matter must be referred to arbitration, and that there's no merit in the contention that 40.2.9 in any way prevents that. So we say that that's the contention of the finance parties, and therefore we say it's either express or implicit waiver insofar as it was necessary, but we say on interpretation, a proper interpretation of Clause 40, there is no need for a waiver. But insofar as the court needs any comfort, we give that tender to court in open court, and there's no difficulty with that, because that is what the parties contended. That said, and if I may just say, it does not follow from the desirability of the waiver that a waiver is actually a requirement, because no matter what the court thinks about there being an absolute immunity or immunity from suit, it does not mean that the court can look behind the Immunities Act and the host country agreement. That confers immunities, and therefore, insofar as South African courts are concerned, those immunities apply. So we say the Immunities Act must be applied in its terms, and it doesn't give jurisdiction to the court to circumvent it. It might be subject matter of a future constitutional challenge by Kalagadi, but that's a separate issue. And then the fourth point that we would make on the immunity issue, and it's quite important, is that there's no evidence before this court that there is no other remedy. The AfDB is based on the Ivory Coast. It has business. It has business offices in various jurisdictions. There's no suggestion that other courts have no jurisdiction over the AfDB, and it's completely immune from all process forever. And therefore, this court can't make an assumption that this is the last chance saloon for
do I need to go
Kalagadi.
there?
You don't. No.
Bearing in mind that there's this concession made now.
Yes, absolutely. We say you don't need to go there even on the terms of the agreement, or the concession, or the clear Immunities Act provisions. For all of those reasons, each one is dispositive of the matter, and we say we would be entitled to our relief on any basis.
You accept that should this court stay the court proceedings and that the matter be dealt with by way of arbitration, that the court needs to be certain that this point is not going to be raised, AfDB's immunity.
Well, we've already waived it. So.
We've already waived it, okay.
Yes. So we submit for all those reasons that we are entitled to either a stay or dismissal. And we say that actually the court would be well within its rights to dismiss the application by Kalagadi. So first of all, we seek that our application for leave to appeal be granted, that the appeal be upheld, that the order of the High Court be set aside and replaced with an order either dismissing the application insofar as it concerns Kalagadi, the borrower, or staying that application and referring the matter to arbitration.
Yeah, but insofar as the interdictory relief is concerned, should there be some sort of carve-out in respect to that?
So insofar as it concerns the shareholders? Yes, so insofar as the stay would be in relation to Kalagadi's application vis-à-vis the lenders, not the shareholders, any shareholder aspect that the shareholders bring in their own right. Okay. And that will obviously have to be determined by the High Court if it's still relevant.
Well, it can be dealt with by the High Court at a later stage.
If it's appropriate to do so, yes. Yes, so Justice, we submit that that's our case. Unless there are any questions from the bench, further questions. Obviously, we've been inundated with questions.
Thank you. I'm sorry.
But if there are any further questions, we're very happy to answer them.
Yes,
otherwise, I'll deal with everything in reply.
You'll have that opportunity in reply.
Thank you. Thank you.
Thank you very much, Mr. Movshovich. Mr. Gautschi.
May it please the court. Justice Kathree-Setiloane, Mr. Luthuli and I appear for the Kalagadi parties, the respondents in this matter. I will deal with the immunity point, and Mr. Luthuli will deal with the arbitration point. So we've divided the argument between us. As an important starting point, it it must be borne in mind, and this was not before the Supreme Court of Appeal because of an administrative, we say, glitch in the office of the registrar of that court, that the two matters were not put together when leave to appeal was sought. But the Kalagadi application is in essence a counter-application to the business rescue application.
It was brought under the same case number?
No, different case number. And it
That's
was
unusual for a counter-application.
Well, simply because there were more parties involved in the Kalagadi application, and rather than do a joinder, a counter-application and a joinder, we brought a separate application. But in substance, it is a counter-application, and it is our case that success in the Kalagadi application will be a complete answer to the business rescue application. So
I need to understand that,
yes,
Mr.
although the
Gautschi.
relief is different, although the one asks for business rescue, the other asks for the financial model to be revisited and for a restructuring. Essentially, what Kalagadi says is, you, the IDC, are responsible for our financial position. And if it succeeds in the Kalagadi application on that score, it is a complete answer to the business rescue application. So the two have to be seen together and they joined at the hip, and they must be heard together. And that will be dealt with more fully in the arbitration section.
Very well.
If I could then go to the immunity itself. And we submit that the High Court was correct to have found that the AfDB does not enjoy immunity. And we submit that it does not enjoy immunity for two essential reasons. The first, I'll just mention them and then I'll deal with them. The first is that the AfDB agreements, the parent agreement and host country agreement, have not been domesticated into South African law. And the second is that it cannot enjoy absolute immunity because there is no alternative remedy for the Kalagadi parties. Let me deal with the first one first.
Yes.
The domestication into South African law. Now, there is a clear distinction drawn in our legislation between an international agreement or treaty being binding on the Republic as a state and being domesticated and binding on the citizens of the Republic. Now, it's being domestic law in the Republic of South Africa. This distinction is very clear in Section 231 of the Constitution. Could I refer you to that, page 4 of the abridged record?
Yes, I'm with you.
And if we could look at sub 2, 231 sub 2, an international agreement binds the Republic, and we emphasize those words, binds the Republic, in other words, as a state, only after it has been approved by resolution in both the National Assembly and the National Council of Provinces, unless it is an agreement referred to in subsection 3, and we can ignore that. It's not one of those. Sub 4 says that, in contrast, an international agreement becomes law in the Republic when it is enacted into law by national legislation. And we don't have to read any further than that. So there is this clear distinction between what is binding on the Republic as a state and what is binding as law. And what is clear is that only when it is enacted into legislation does it become law binding on Joe citizen.
So it's the international agreements. So you're saying it's both the host country agreement and the parent agreement that have not been incorporated into law.
Yes.
Have not been domesticated.
Correct. Our learned friends have said, and this is a new submission, and there's no evidence for it with respect, that that was ratified by Parliament in 1995. All that happened in 1995, that is in the full record, is that in 1995 the United Nations issued a document which recognized the admission of South Africa as a member. That's all that happened. That's all that's on the record in 1995. There was no ratification by Parliament at that time.
What then is the purpose of this Immunities Act?
Well, the Immunities Act
and
is...
the power that the minister has to confer immunity and certain privileges on
We submit...
the named organizations and officials.
We submit that the purpose is, and I'll come back to contrast in that act itself, but the purpose is to allow the minister to recognize an organization, and this is an international organization, to recognize it for purposes of what the Republic, as a state, will confer or recognize in that organization. So 5 subsection 3 of the Immunities Act, and I'm not sure if that has now been made available to the audience, but
Sorry,
it
5,
says
3,
5
yes,
sub 3,
yeah.
any organization recognized by the minister for purposes of this section enjoys such privileges and immunities as may be provided for in any agreement. And then 7, any agreement whereby immunities and privileges are conferred by any person or organization, to any person or organization in terms of this act must be published by notice in the Gazette. That only gives rise to a contractual relationship, rights and obligations between the organization and the state and the Republic as such. Contrast that.
But we do have an agreement.
No, there is an agreement, but the agreement has not become domestic law. That is the crucial aspect in this matter. And if one contrasts that with Section 2 of the Immunities Act, for instance, which says in terms, the conventions, and this is not a convention, the conventions have the force of law in the Republic. So there is always this very clear distinction drawn in the legislation between what is binding on the Republic and what is binding on, as a matter of domestic law, on the citizens of the country. And it would be very strange, with respect, if a minister it would be incongruous if a minister were able to take an agreement and say it is now law in this country, which is the domain of Parliament.
So has there been any challenge to the minister's powers under the Immunities Act?
No, because we simply say it doesn't take it far enough. It just gives, we don't have to challenge it constitutionally because...
So there's certainly no constitutional challenge to the Act.
No,
or
there
the
isn't.
provisions
But we
of
don't
Section
have
5
to.
or 7.
We don't have to because all that the minister has done is to recognize the organization for purposes of what is binding on the Republic. So that is the first point that we make, is that there is, in fact, there's no evidence that Parliament, either the National Assembly or National Council of Provinces, or even the Parliament before the present Constitution, the 1996 Constitution, that no evidence that Parliament ever recognized this and made it domestic law. And of course, if that is correct, then there is no immunity
but Mr.
as against
Gautschi,
Kalagadi.
there's a contradiction in terms here. Now, you have an Immunities Act that stands and is currently in place and valid, and you have now Section 231, which you contend has not been complied with,
Yes.
because these agreements are international agreements and have not been domesticated. Now, how does the court deal with this? I mean, it's from a practical perspective, I have difficulty with how to reconcile these two instruments.
We submit the Constitution trumps the Immunities Act, and that the Immunities Act does not give the minister the power to make an international agreement into domestic law.
Yes, but can I at this point make that finding? Is that an appropriate finding
Absolutely.
to make?
Absolutely,
in
with
this
respect, Justice Kathree-Setiloane. We've raised pertinently that Section 231 is of application. If the lenders cannot bring themselves, or AfDB in this case, cannot bring itself within the Constitution to say we've complied with the Constitution, Section 231 has been complied with, it is domestic law. If they can't do that, there is no immunity. And that's the first point. If I could move on
Just in terms of paragraph 5, and I think Mr. I think reference was made to paragraph 2315. The Republic is bound by international agreements which were binding on the Republic when the Constitution took effect.
Yes, the interim constitution was no different. And if anything happened in 1995, then the interim constitution would apply. That section, the equivalent is section 231(3), which says that where Parliament agrees to the ratification of or accession to an international agreement under subsection 2, such international agreement shall be binding on the Republic, first point, and shall form part of the law of the Republic, second point. Again, the clear distinction drawn. Provided Parliament expressly so provides, and such agreement is not inconsistent with this Constitution. As I have said, the only document that is that we have, and that is in the bigger record, is a United Nations document saying you are now a member. We recognize you as a member of this of the AfDB.
Wasn't there a certificate published that was gazetted?
The certificate was in 2024 or so.
2017 and 2024.
But none of the documents, none of the certificates, none of the government gazettes, none of the documents recognize the agreement as being law in the Republic.
Okay.
That is the bottom line of the submission.
So basically, if I understand your submission, is 231 applies.
Yes, 231
right?
must apply.
And there has been no compliance for 231, so therefore... It might enjoy immunity as far as the Republic is concerned. Yeah. It does not enjoy immunity vis-a-vis the citizens of the country, of which Kalagadi is one. Tell me to get hurry up. Let me make the submissions on the second point. Well. There's a considerable body of authority worldwide to the effect that a state or international organization which engages in commercial activity does not enjoy absolute immunity but a restrictive immunity. And that you can only have absolute immunity if there is an alternative remedy. And the authorities are in the High Court judgment. Some of them are. Yeah. There are many, many more. The seminal authority is the Court of Appeal in England, a decision by Lord Denning, Trendex Trading. And it spells out very clearly that there's a distinction between states in the past that were involved with foreign affairs and defense, and as an international rule of law, it was recognized that they have absolute immunity. But then they started engaging, says Lord Denning, 50 years, and that was before 1977, started engaging in commercial activities. And once they engage in commercial activities, then they should be held to the laws of the market. And then restrictive immunity was recognized. And what is then crucial is to ask, if they want to enjoy immunity, is there alternative remedy here? And the alternative remedy that they point to is the arbitration clause. The problem with the arbitration clause, clause 40.2.1, read with the non-waiver clause of 40.2.9, is that the arbitration clause is immediately nullified by the fact that in the same clause, clause 40, the AfDB says, we don't waive any immunity here. And what is the immunity for? It's against legal process. As you have correctly debated with our learned friends, arbitration is a legal process. So they say, we'll waive. We'll waive our right to immunity in the arbitration. But we say that doesn't go far enough because the court has a supervising role in arbitration.
You can go to court before to stop the arbitration. You can go to court in the middle to interdict the arbitration. You can go to court at the end to review it, to make it an order of court. When we go to court to make the award an order of court, they'll say, you can't sue us in court. We never waived our immunity for that. You can't review this decision because there's no immunity for that.
Can you make the arbitration order an order of court? Arbitration award an order of court?
You can't.
Would you need to...
You need to go to court for that.
Yeah.
And they'll say...
I'm just thinking about, would the financing parties have to make an election in terms of section, what was it, 40.2.10, or what article?
The point of the business rescue being a court process, and it is a court process to enforce, essentially, to enforce the debt, which we say is also a dispute under the Common Terms Agreement. That process has drawn the parties into litigation in court. Then the AfDB says, but I'm immune. The other point about the immunity with respect is this. The shareholders are not party to the Common Terms Agreement and therefore not party to the arbitration agreement. So they are left, the court says, well, they say, you can go to court for your interdict. But in court, they're faced with the immunity of the AfDB. So they are left remediless. They can't go to arbitration because they're not party to the arbitration agreement.
Yes, but the waiver that Mr. Movshovich just, he basically said we waived our right to...
only to arbitration.
To arbitration.
The only waiver that
the
has
immunity
been given...
insofar as arbitration is concerned.
Yes, only that. But not to court process which surrounds the arbitration, and not for the shareholders who can't go to arbitration, who must go to court, and are suing inter alia the AfDB.
But the shareholders, as I understand, the shareholders can still go to court. No, in the event that, that it's suspected that the IDC or African Development Bank want to call up those guarantees, intend to call up those guarantees,
What the shareholders seek in court is an interdict against the lenders, including AfDB. The AfDB will say, but you can't sue me in court. I have immunity. So the shareholders are literally left remediless. The others can go, the Kalagadi can go to arbitration. And
are you saying so that will have impact on the shareholders, basically?
Absolute impact. Absolute impact. If I could make one further point, then I'll close, and then my learned friend, Mr. Luthuli, can pick up from there. But that is that the other point that is made is that because the AfDB has immunity and can't be sued in court, therefore there's a non-joinder of the AfDB, and therefore vicariously the IDC also enjoys immunity. We submit that is an incorrect statement. It's a misconception, because the raising your immunity defense is a voluntary act. You voluntary saying, I don't have to be joined here. Then it can never be an obstacle for us that one party does not want to be joined and the other says, well, I've got a vicarious immunity here, that we say is a misconception.
So you're saying this immunity point, whether the African Development Bank has immunity or not, it still impacts any other litigation that needs to happen outside of the arbitration.
And because the non-waiver clause prevented even arbitration, and eventually it was recognized in the argument in the SCA at the death. It was recognized without board approval, apparently. We've never seen a resolution of the board of the AfDB. Counsel says, I waive, but the waiver doesn't go far enough and causes problems anyway. So there is no alternative remedy, hence the immunity.
Well, that's the important,
no alternative remedy, one would not recognize the immunity under a host of authorities.
Very well.
Let me stop there, and then my learned friend, Mr. Luthuli, can deal with the arbitration point.
Thank you.
Thank you.
Mr. Luthuli?
May it please the court, Justice. Justice, I will start my submissions by answering the question that you asked in your opening remarks. We accept that the attitude of the South African courts is to strictly enforce arbitration agreements and to construe any exceptions very narrowly. We would submit that we fall within the exception of Article 8.1 of the International Arbitration Act.
But even if you say that a court has jurisdiction, would a South African court have jurisdiction in this case?
It does.
What is the law that applies in respect of this agreement?
The agreement is governed by English law,
Yes.
but we would submit that the South African court is competent to apply English law.
Very well.
On the exception, Justice, we would submit that we are not suggesting that the arbitration agreement is void. We only rely on the exceptions of inoperative and incapable of being performed.
But what is the basis, on what basis is the common terms agreement inoperative?
Justice, we would submit that on the terms of the agreement itself, I would go back to the debate that arose between the court and Mr. Movshovich for the lenders in relation to specifically clause 40.2.9, which says it does not waive the immunity. And the submission was that the court gets through that by interpretation. We would submit that interpretation does not assist. And therefore, if the court does find that the immunity stands in the way, that itself makes the agreement inoperative.
How do I agree, in light of the test or the method of interpretation that the courts have time and time again restated, on interpretation of contracts, on interpretation of statutes, how do I read clause 40.2.1 in any other way but as being peremptory, as arbitration being peremptory?
My lady, you have to read not just the clause 40 as a whole, you have to read...
But then you also want me to read away terms like shall and words like shall. I mean, obviously I have to pay close attention to the text of the Article
agreement?
40.
So my lady would submit that on the authorities that have already been cited by the lenders, those are the authorities that should guide you in the interpretation exercise. Not only must you read clause 40 as a whole, you must read the entire CTA, the Common Terms Agreement, as a whole.
So what are the other provisions in the CTA that then support the contention that you, the position that you contend for?
There will be standard agreement. There will be standard clauses like the whole agreement clause, my lady, that this is the whole agreement between the parties. None of the other representations made by the parties, orally or otherwise, will be binding unless they are reduced to writing. All of those clauses will have to be considered by your ladyship, and there can be no real dispute that there is a clear tension between clause 40.2.1 and clause 40.2.9, because clause 42.9 is also in peremptory terms, that we do not waive our immunity.
So you're saying there's a contradiction between 40.2.9 and 40.2.1.
There is a clear contradiction, my lady. And the court cannot resolve that contradiction through interpretation. And perhaps to anchor those submissions, my lady, I would have to take the court through the authority.
Well, then how does the court deal with this? How does the court deal with this conundrum that it's now faced with this contradiction?
So, my lady, before I actually answer the question directly, and I promise I will come to the question directly, let me just take a step back, because there are a number of other difficulties before I get to that point that we submit the lenders run into. So first, my lady, the first, Justice, if we can consider the exception under Article 8.1, and I would ask the court to read Article 8.1 of the model law together with me. So the article says, a court before which an action is brought in a matter which is the subject of arbitration agreement. The matter which is the subject of the arbitration agreement. The matter, my lady, it's important to distinguish between what I'm going to call the dispute from an enforcement mechanism that is chosen by the lenders, and also that must be distinguished from the forum that the lenders choose to go to enforce the terms of the agreement. So the dispute in this instance is not the business rescue, it is not the arbitration. The dispute is one, insofar as Kalagadi is concerned, whether Kalagadi is in default. And if it is in default, whether it is entitled to a restructuring of its loan facilities with the lenders. Mm-hmm. The IDC has taken the route of enforcing Kalagadi's indebtedness repayment through business rescue proceedings. Because it chose business rescue proceedings, it could only go to court. But it could equally have sought enforcement of those obligations in arbitration.
Yes, but how does, in order to escape the arbitration clause, you have to bring it within the last two lines of Article 1,
Indeed.
8.1. Now,
indeed, if I may go...
Is the agreement null and void? Is it inoperative? Is it incapable of being performed?
My lady, we submit that the agreement is not null and void, but it is inoperative and incapable of being performed.
Why do you say that? I still don't understand. I don't understand why it is inoperative.
If I may, my lady, first take the courts to the Canadian authority, because it is the only authority that we could find that has actually interpreted the meaning of those terms. And it uses exactly the same language quoted from the Canadian Arbitration Act, which is taken directly from the model law. So it's exactly the same language. And the authority that we're referring to, my lady, is Peace River Hydro Partners versus Petro West Corporation. And it is reported in 2022, Volume 3 of the Supreme Court report, okay. Supreme Court of Canada report.
Mr. Luthuli, this authority was only handed to me 5 minutes before we came into the session.
Indeed.
So can you quickly take me through it? And
indeed it was, yeah. My lady. My lady, I'm not going to go through all the relevant paragraphs. However, I would point at paragraph 132. At 132, the court would actually, that appears on page 320 at the top of the page. Page 320 at the top of the page, paragraph 132.
320. Yeah, sorry, 1 second. Yes, sorry. Go ahead.
At paragraph 132, my lady, it shows the submission that I've just made, that the language is actually drawn from the model law, Article 8.1, that is confirmed there.
Yes, understand. It's literally stating what's in.
It is
in Article 8.
Indeed, my lady.
Right, but now how does that help me in any way?
And
unless you've made out, you need to make out a case for why it's inoperative, and that's not on your papers.
My lady, we would have made the case if that case, if Article 8.1 was relied on in the High Court. It never
yes,
was.
but did it have to be relied on in the High Court? I mean, from a reading of the Common Terms Agreement, it's quite clear that it's an international agreement. That at the end of the day, the court had to decide whether or not it had jurisdiction in this matter.
My lady, we did make the case, and the case is simply the following. The IDC has made an election to sue Kalagadi to enforce the debt in court. because the IDC has made an election, which it is entitled to make in terms of the Common Terms Agreement. That, therefore, renders the agreement inoperative.
Okay, so you're saying because it made the election to go to litigate in respect to the business rescue, that then applies across the board?
That is correct, my lady, because...
To a dispute that even arises...
To the dispute.
That arises from the Common Terms Agreement, or out of?
The dispute is Kalagadi's indebtedness, its default in terms of the Common Terms Agreement, and whether it is entitled to a restructuring. That is the dispute. That dispute arises squarely out of the Common Terms Agreement. The IDC has decided to go to court to litigate in relation to that dispute. And having decided to go to court to litigate in relation to that dispute, Kalagadi is therefore entitled to raise its defense in court. The Kalagadi application is a defense to the business rescue application.
Very well.
It need not necessarily be under the same case number for it to be so, but it was found by the High Court to be a complete answer to the business rescue application.
And the fact that the African Development Bank was not part of that application? Was not cited as an applicant?
My lady, Justice, there are two answers to that. Firstly...
All right, you've got another 2 minutes,
yes.
And then I need to wrap up.
First, Justice, once one of the lenders has made the election, that is sufficient. Two, in terms of the intercreditor agreement, which is concluded by the lenders, business rescue and liquidation and other proceedings is one of the proceedings which requires the lenders to agree.
Yeah.
We do not know, as the Kalagadi parties, what is happening behind the scenes between the lenders. We cannot tell the court whether AfDB agreed to that or not. However, what we do rely on, my lady, is that even though it was not cited as a party, it was given notice of the BR application as an interested and an affected party. Having been given notice of the BR application, it had a choice. It could either object or it could fold its arms. It chose to fold its arms. Therefore, the court is entitled to take that as either an acquiescence, or the court, we submit, has to find that the AfDB is now stopped from distancing itself from the BR application under those circumstances. And based on that, my lady, on that alone, we would submit that renders the arbitration agreement within the Common Terms Agreement.
Okay. Is there anything more that you want to make submission on, Mr. Luthuli?
Justice, there are other grounds that we have raised, which is that the dispute includes parties that are not party to the Common Terms Agreement, and also there are other issues which are constitutional and statutory issues that relate to the IFDB. We would commend paragraph 139 because that is the paragraph that was relied on behalf of the lenders to submit that those considerations do not avail us. That is the incorrect reading of the dictum in that paragraph, my lady. What is stated in that paragraph is that those considerations standing alone would not be enough. We do not rely on them standing alone. We rely on them as the conspectors of all factors that this court needs to take into account in order to decide whether to stay the proceedings in court and send us to arbitration.
Very well.
And finally, my lady, and finally, Justice, we would submit that this court cannot stay the Kalagadi application and send Kalagadi to arbitration and allow the BR application to proceed, because in effect it would be taking away a defense from Kalagadi and rendering it a sitting duck in terms of the BR application. Therefore, if the court were to be minded to suspend, it would have to suspend both the BR application and the Kalagadi application. And that way, then all parties will be protected in that the IDC cannot have its cake and eat it by going to get a court order, which we submit in terms of the moratorium under Section 133 of the Companies Act would actually neutralize the arbitration process in any event. It therefore would have to be stayed in order for the court to ensure that the arbitration
Very
is
well.
effective.
Thank you, Mr. Luthuli.
Court, please.
Mr. Movshovich, do you want to do a very short reply?
I can do very, very, very short reply because I think we've run out of time.
Yeah.
So the first point is in relation to the Supreme Court of Canada authority. It makes it quite clear that in arbitration law, the term has been used of inoperative to describe arbitration agreements which, although not void ab initio, have ceased for some reason to have future effect or have become inapplicable between the parties in their dispute. And we say that that's not the case here at all. The dispute continues, the agreement is still in place, and there's no reason to overlook it. The business rescue proceedings, it's not before this court to decide what happens to the business rescue proceedings. It might well mean that if stay is granted in the Kalagadi application, that has a similar effect on the business rescue proceedings. And there's nothing to gainsay that. We've dealt with the waiver point, so I'm not going to retraverse that. The clauses that are cited in the common terms agreement, whole agreement clause, no representation clause, they don't assist the interpretive exercise in this case. And in relation to the immunity point, it is not correct that the record doesn't reflect ratification. It reflects the instruments of ratification being deposited with the UN Secretary General, which is the way that the agreements come into force at an international level. That agreement came into force in 1996. That's quite clear. With the new constitution in 1997, in February 1997, it then became part of South African law. But we don't even have to rely on that, as I submitted. We rely on the host country agreement and the fact that that is, under the Immunities Act, a self-standing basis on which immunities can be recognized, and in the absence of a constitutional challenge, there's nothing to gainsay that. So for all those reasons, there are many other things that I could have traversed, but for all those reasons, we say we must succeed.
Thank you very much. Thank you for the very full argument. I will take that into consideration, and judgment is reserved. Thank you very much. Okay, we were going to do questions and answers, and we don't have time for that. But you've heard the argument, you've heard the engagement with the court, and it's for you now to decide whether arbitration agreements, depending on the context of the case, should be enforced strictly, or whether the court should play a more expansive role in the adjudication of arbitral disputes. Thank you very much.
Thank you so much to our judge and, of course, the two teams for the Kalagadi IDC Moot and Judiciary-led discussion and dialogue. One more round of applause, please, everyone.